In the first 5 minutes of sitting in that courtroom, he learned three things. 1, that the judge wouldn't look him in the eye. 2, that his father's name had already been decided guilty before it was even spoken. And 3, that silence in places like this was not neutrality. It was power. Controlled. Measured. Designed to remind people like him that they didn't belong here, unless it was in cuffs. He was 13, old enough to feel the difference between fear and fury, young enough that they still mistook his quiet for ignorance, and dressed too clean, too calm, too composed to fit into the story the prosecution was building around his father, a story about resistance, disorder, and obstruction. They didn't know about the folder in his lap. They didn't think he had spent 2 weeks reading civil rights law under the flickering hallway light outside their one-bedroom apartment while his father fell asleep grading papers. They didn't know he'd been preparing for this moment, not out of ambition, but out of necessity. Because his father's lawyer didn't care. And the system? The system had already forgotten how to listen. The judge flipped a page, sighed, looked at the boy like a smudge on the bench. "You're the son?" she asked. "Yes, ma'am." Her tone tightened. "Let's be quick. I'm not in the mood for lectures." He didn't blink. He didn't flinch. "I'm not here to lecture," he said. "I'm here to correct the record." The prosecutor laughed under his breath. The public defender didn't even lift his head. "You've read the law?" the judge said flatly. "That's ambitious." She smiled, but it wasn't warm. It was the kind of smile people use right before they crush a thing they don't understand. He raised his folder slowly. "Yes, ma'am. I've read Title 17, Section 871, Georgia Code of Criminal Procedure. I'd like to begin with that." And for the first time that morning, the room went still, the way a forest stills before lightning strikes. Not because the boy raised his voice, but because he spoke like someone who had nothing left to lose and everything to prove. Of all the places he never wanted to be, the witness stand was at the top of the list. It wasn't the height or the wood that creaked under his sneakers or the uncomfortable way everyone turned to look at him like he was a curiosity in a museum. Too rare to ignore, too unfamiliar to respect. It was what the room assumed the moment he stood. Not just that he was young or poor or black, but he didn't know anything, that his presence was ornamental, a formality, that he would crack under pressure or mumble or hesitate or say something cute before being dismissed with polite contempt, that he would confirm everything they already believed about boys like him in places like this. But the boy didn't stutter, didn't stall. He opened the folder he'd brought with him and began to speak, not with emotion, but with a careful cadence he'd practiced night after night, voice steady, eyes forward. The kind of voice that didn't beg to be believed. It dared you to dismiss it. He began not with his own story, but with the facts, timestamps, testimony inconsistencies, and the part the police report left out. The exact moment the officer turned off his bodycam, 23 seconds before the alleged resistance occurred. He referenced bodycam policy, cited public protocol standards, and recited section codes like scripture. When the prosecutor tried to interrupt, the boy paused and said, "I'll answer that in a moment, but first let's clarify the chain of events." There was a subtle shift in the room. Not a gasp, just the quiet sound of authority bending. The judge looked down at her bench, then back at the boy. Her smile had vanished. The prosecutor, now leaning forward, tried a softer approach. "You're very prepared," he said, tone falsely kind. "But you do understand this is a legal matter, right? Not a classroom exercise?" "Yes," the boy said without missing a beat. "Which is why I came here with facts, not feelings." That sentence, so precise, so unnervingly adult, landed like a gavel strike. And the court, which moments ago had swallowed him whole with the arrogance of 1,000 other days just like this one, was beginning to listen. Because this wasn't just a child speaking, it was the law, sharpened and weaponized in the hands of someone no one thought could carry it. What they didn't know, what none of them could have guessed, was how long he'd waited for this moment. Every night after school, he'd sit beside his father while he graded papers, reading civil rights case law on a cracked tablet, taking notes with a pencil stub on the back of receipts. How he'd memorized constitutional amendments not for school, but for survival. How he'd watched the video of his father's arrest more than 24 times, looking for what wasn't said, for what the officers hoped no one would catch. How he knew that due process wasn't just an idea, it was a right they depended on most when they were most likely to be denied it. Now, standing there under the weight of a courtroom not built for him, he felt none of that weight. Only clarity. Only fire. And when the judge leaned forward and asked, "What exactly are you alleging?" The boy turned the page, looked her dead in the eye, and said, "I'm not alleging anything. I'm proving it." And that was only the beginning. The judge blinked just once, but it was enough. A flicker of surprise cracked through the lacquered calm of someone used to owning the room. She wasn't prepared for this. None of them were. This wasn't supposed to happen. A kid wasn't supposed to walk in here quoting constitutional law, armed with precise timestamps and an unnerving sense of control. He was supposed to be intimidated. Small. Manageable. Instead, he was turning the courtroom into a chessboard, and he'd already moved his queen. The boy reached into his folder again, sliding out a grainy printed photo. It was a still from a video most people in the room hadn't seen. "This was taken at 7:13 p.m., he said. "It shows the officer's right hand on my father's collar before any verbal warning was given. You'll notice the timestamp aligns with the camera cutting off. It was manually disabled. That violates departmental guidelines per Atlanta PD Internal Use of Force Policy 4.6. There it was. Police misconduct. Spoken without drama, without threat. Just delivered like a matter of weather. Cold and undeniable. The defense attorney, previously slouched like a man already halfway to the parking lot, sat upright for the first time all morning. He hadn't done any of this prep. Hadn't asked the boy to speak. He hadn't even realized the boy had been building a case stronger than anything he could have filed. The prosecutor shifted uncomfortably. "Where exactly did you obtain this video?" he asked, his tone sharpening. The boy didn't hesitate. "I filmed it. I was in the passenger seat. It's been uploaded to a secure cloud and time-stamped via metadata." He looked directly at the jury box. "It's unaltered." No one spoke for several seconds. Not the bailiff. Not the stenographer. Even the ceiling fan seemed to hum a little slower, as if the air itself had grown thick with the tension of a narrative beginning to collapse. Outside the courthouse, the first reporters were starting to gather. Word had leaked. Viral courtroom moments don't stay contained for long. The live stream from a local law student who'd been sitting in the back row was quietly climbing past 40,000 viewers. Hashtags were beginning to trend. #KidLawyer, #silence, no more, #justice for Mr. Reynolds. The boy didn't know that yet. He was too focused on the facts. But the world was starting to notice. "What are you implying about Officer Granger?" the judge asked, voice suddenly taut. It wasn't just a question. It was a warning, a pressure test. The boy didn't flinch. "I'm not implying anything, Your Honor," he said. "I'm stating that his actions were inconsistent with the official report and in violation of departmental policy." He paused. "Which is either negligence or misconduct. I'm not here to make that judgment. That's your job." The room shifted again. No one had ever spoken to her like that. Not from the stand. Not without rank or robe or power behind them. But this boy had something more dangerous. The truth, delivered in a voice no one could predict and no one could stop. And for the first time in a long time, the courtroom didn't feel like hers. It felt like his. The courtroom was no longer a chamber of law. It had become a pressure cooker. Every eye was fixed on the boy, not because he was loud, but because he was right. And right was dangerous here, especially coming from someone who wasn't supposed to understand how the system worked, much less expose where it cracked. The judge adjusted her robe, as if the fabric itself could reassert control. But the moment had already escaped her. The air had changed. Something irreversible had happened when the boy uttered the word misconduct, when he dared to suggest that the sacred word of an officer might be flawed. It wasn't just a challenge, it was a rupture. and no one in that courtroom knew how deep it would go. He turned another page in his folder. On page 6 of the arrest transcript, Officer Granger claims my father shoved him backward, prompting the use of force. But this contradicts 2 witness statements gathered that night, both of which I've submitted as part of the public complaint file. Neither witness recalls any physical contact initiated by my father. One of them is a retired teacher, the other a restaurant manager, both neutral parties, both credible. The prosecutor stood this time, finally rattled. Your Honor, we cannot allow this child to hijack due process. But the judge didn't respond. She was staring at the printed photos on her desk, the timestamps circled in red, the quotes from witnesses she hadn't reviewed closely. There was sweat at her temple now, just a trace. But in a courtroom, nothing goes unnoticed for long. The boy kept going. He wasn't angry. He was surgical. His voice never wavered. I'd also like to present a copy of my father's performance reviews. He's a middle school civics teacher. 8 years. No complaints. No disciplinary action. He teaches the Constitution. Every day. The idea that he resisted arrest while picking me up from a chess tournament makes no logical sense. And logic should matter in court. That's when the first click echoed through the room. It was subtle. From the back. A reporter's camera, discreet but unstoppable. Then another. Then a phone lifted, just slightly. Live stream. Quiet chaos disguised as observation. This wasn't just a trial anymore. It was becoming a viral courtroom moment. The prosecutor whispered something to his assistant, clearly trying to control the narrative before it spilled onto the internet. But it was too late. Outside, a crowd had gathered. Signs. Hashtags. Interviews. It had started as one boy defending his father. Now it was beginning to look like a civil rights violation unfolding in real time. Inside, the judge tried to recover. "Young man," she said, her tone sharp again, "do you understand the implications of what you're saying?" He met her gaze calm. "Yes, ma'am. That's why I brought proof." The next document he held up was a printed email from Officer Granger's own department, confirming that no official report of bodycam malfunction had been filed that night. "The policy is clear," the boy said, "and the bodycam footage should have been archived. But it wasn't. It vanished. That violates both public transparency and federal funding requirements for digital evidence retention." The courtroom cracked, visibly this time. The public defender's face turned white. He whispered something to the father, whose eyes widened, not in fear but in recognition. His son had found the one thread that might unravel everything. The prosecutor pushed forward, louder now. "We are not going to litigate protocol based on the opinion of a child." But the judge raised her hand to silence him. The silence returned, this time heavier. It wasn't respect, it was the weight of momentum shifting. The boy stepped closer to the bench. "I'm not asking you to trust me. I'm asking you to verify the facts. Because if you won't, someone else will. This is being recorded, it's public, and the public still cares about due process even if this courtroom forgot." His voice was still soft. But now it had gravity. And gravity can't be ignored. And then it happened. The door at the back of the courtroom opened, slowly. 2 figures entered. One wore a dark suit and carried a DOJ badge on his hip. The other was from the ACLU, clipboard in hand. Neither said a word. They just sat in the last row, watching. But their presence sent a ripple through the room, because they weren't here to spectate. They were here to observe a potential wrongful arrest case. The boy didn't even turn around. He didn't need to. He had already lit the match. Now the system was beginning to feel the heat. The presence of the DOJ and ACLU wasn't announced, but it didn't need to be. The judge saw them. The attorneys saw them. The audience saw them. And more importantly, the boy knew they were watching. Not just him, but the room. The silence that followed wasn't empty. It was full of the possibility that this case was no longer just local. It was federal now. Police misconduct, wrongful arrest, suppression of evidence. The kind of words that don't just echo, they detonate. The judge adjusted her posture, more alert now, measured. Her voice lost its edge, replaced with something colder. "We will take a short recess to review the new materials submitted." But the boy stepped forward before she could finish. "With respect, Your Honor, I'm not finished." It wasn't defiance. It was purpose. And the weight in his tone made her pause. She nodded. He pulled out the final sheet in his folder. "This," he said, "is the written statement my father tried to submit the night he was booked. It was never entered into evidence. The officer said it wasn't necessary, that the report speaks for itself." He handed it to the bailiff, who hesitated, but took it. Inside was a calm, detailed account from a teacher who'd spent his life teaching kids about civic duty, rights, and responsibilities. A man who had been pulled over, not for a moving violation, but for fitting the description. Who had been ordered out of the car with his hands up in front of his son. Who complied. Who asked a question and was tackled for it. No resisting, no threats, just questions. That single paragraph was more damning than the rest of the case combined. The courtroom didn't explode, it imploded, quietly, powerfully, and all at once. The judge called recess not out of convenience but necessity. She needed time to regroup, to breathe, to hide the tremor behind her voice. As she exited, the prosecutor stormed toward the hallway, phone pressed to his ear, muttering damage control. The bailiff exchanged uneasy glances with the clerk. The father? He stared at his son as if seeing him for the first time, not the boy he raised, but the man who had just walked into a lion's den and made the lions back down. Outside, the courthouse steps had become a stage. Reporters were stacking questions faster than microphones. Is this another case of racial profiling? How did a teenager dismantle a criminal case in under an hour? What will the DOJ do next? Meanwhile, the boy sat in the corner of the hallway, exhausted, but not shaken. His hands trembled slightly, not from fear but release. The adrenaline was leaving, but the fire remained, because the truth wasn't just spoken, it was heard, and that was everything. Inside the courtroom, the judge stared at the transcript of the boy's testimony, line by line, timestamp by timestamp. She saw what she hadn't wanted to see, or maybe what she had always suspected but never had to confront, until now. The system had a leak, a crack. A boy had walked in through that crack and shown the whole world what was inside. She returned to the bench 20 minutes later. The courtroom reassembled itself. The boy stood again. She didn't look at him the same way this time. There was no smirk, no distance, just a strange stillness, like a storm that knows it's already lost. "I've reviewed the supplemental materials," she said slowly, "and given the discrepancies, the lack of preserved bodycam footage, and the failure to follow due process during booking, I am dismissing the charges against Mr. Reynolds without prejudice. This case is no longer suitable for this courtroom." A beat. 2. Then the room broke. One gasp, then two, then a low murmur. The boy didn't react. His father didn't move. Because this wasn't a victory parade, it was survival. But as they exited the courtroom, surrounded by people they didn't know but who now knew them, the boy finally looked up. Toward the DOJ agent. Just a glance. The agent nodded, barely perceptible, but it was there. A signal, a recognition. This wasn't over. This was the beginning. And the boy, once labeled too young, too quiet, too ignorant to matter, had just reminded the world that knowledge isn't about age. It's about truth. And when spoken loud enough with the right timing, it silences everything. The news didn't break. It detonated. What started as a local incident, another black man wrongfully arrested, was now a national conversation. By the time the sun dipped behind the courthouse that evening, the boy's speech had been clipped, captioned, and watched over 10 million times. A 17-second reel of him saying, "I'm not asking you to trust me, I'm asking you to verify the facts," had already been played on CNN, MSNBC, and in courtrooms across the country. But while the world was still catching its breath, The real reckoning had only just begun. Because this case wasn't an outlier. It was a door, and someone had just blown it open. 2 days later, the Department of Justice returned, not to spectate, but to launch a civil rights investigation into Officer Granger and his precinct. It turned out this wasn't his first body cam malfunction. It was his sixth. 5 others had been buried under paperwork, technical excuses, and administrative shrugs. But this time, someone had put the dots on paper, connected them, in front of witnesses, on public record, on video. The DOJ didn't come to ask questions. They came with subpoenas. The twist didn't come in a headline. It came in the details. The boy's file, his quiet, meticulous folder, contained more than just evidence for his father's case. It contained documents no one expected him to have. Redacted memos he'd requested under Freedom of Information Act filings. Internal logs showing which officers had accessed which digital evidence databases. Names, dates, patterns. They found an email sent from Officer Granger to another officer, dated 2 months before the arrest. It read, "This guy Reynolds is one of those activist types. Teaches kids about police corruption. I'll catch him slipping one day." It had been dismissed at the time as venting, but in light of everything, it was premeditated profiling. When federal investigators confronted Granger, he lawyered up. But the precinct had already turned cold. Phones stopped ringing. The chief of police went dark. Because now it wasn't about one mistake, it was a pattern, a culture. The arrest wasn't random, it was targeted. And then came the lawsuit. The Reynolds family filed a civil rights lawsuit not just against Granger, but against the department itself, for failing to discipline him, for enabling systemic misconduct, for violating public trust. The damages? 7 figures. But the message wasn't about money. It was about accountability. And that's when the real twist landed, not in court, but in front of a microphone. The boy stood beside his father and said calmly, "We're not just suing for us. We're suing for every family who didn't have a camera, for every dad who didn't have a kid with a folder full of proof. We're suing because due process shouldn't depend on whether or not your son understands the Constitution better than the arresting officer." It wasn't a soundbite. It was a scalpel, clean, deep, impossible to ignore. And suddenly the country had a new face for justice, not a judge, not a politician, a teenage boy who had weaponized knowledge, law, and timing, and who now had the full weight of the law behind him. But the punch didn't end there, because 1 week later, while reviewing Granger's service record, a DOJ auditor found something strange. A sealed internal investigation from 3 years prior, never disclosed. The report detailed excessive force against a juvenile. The complaint had been made anonymously, but the handwriting matched another report. Same ink, same notations, different signature. When that came out, everything collapsed. The sealed report was damning. A 15-year-old boy, wrongfully detained, slammed against a locker outside his school by none other than Officer Granger. No charges were filed. The school declined to comment. The report was labeled resolved administratively and buried, filed in a drawer no one ever meant to open. But the handwriting on the complaint? It didn't belong to the alleged victim. It belonged to a guidance counselor, one who had resigned the same year, quietly, without explanation. The DOJ tracked her down. She was living in Minnesota now, teaching art therapy at a women's shelter. When contacted, she broke down in tears. "I tried to push it through," she said, "but the department warned me it would ruin my career. They said it wasn't worth the trouble." But now, years later, trouble had finally arrived. And it had a name. The DOJ reopened the 3-year-old case, citing new evidence and an active pattern of abuse. Officer Granger was suspended indefinitely. Then came the criminal charges: official misconduct, destruction of digital evidence, and violating civil rights under color of law. He didn't report for duty that Monday. Instead, he was escorted from his home in handcuffs. The local news caught the footage. It spread like gasoline meeting flame. Suddenly, people remembered. Old cases resurfaced. One by one, neighbors, former students, even business owners began coming forward with stories, not all dramatic but unmistakably connected. Traffic stops that went too far. Accusations that disappeared, cameras that failed. The pattern wasn't invisible anymore. It was undeniable. Systemic racism wasn't just an academic phrase. It had names, dates, badge numbers. Now it had a face on trial. And the boy who started it all? He wasn't in front of cameras now. He was back in school, quiet again, watching from a distance as the justice he triggered took form. But one afternoon, as he sat in the library after class, a man in a dark blue suit approached his table. "We've never met," the man said. "But my niece, she watched what you did. She wants to be a civil rights lawyer now." He nodded, unsure how to respond. The man left a card anyway. Department of Justice, Division of Civil Rights. No promises, no favors, just an invitation. Whenever you're ready. Meanwhile, the civil rights lawsuit was gaining traction. Other law firms joined. The NAACP issued a statement. Federal oversight committees began quietly drafting a recommendation for systemic reform in the precinct. A new term echoed through the news cycle: pattern or practice investigation. A full review of the department's culture, hiring, oversight, and internal discipline. This wasn't just cleanup, it was dismantling. The judge who once mocked the boy's presence on record? She quietly recused herself from 2 pending cases involving youth defendants. The public had not forgotten the way she looked at him, the way she flinched when he refused to flinch. That moment was etched online forever, part of the viral courtroom footage replayed in classrooms, community centers, and public forums across the country. Some even called him the folder kid, others just called him a miracle. But the boy never claimed a title. He didn't need one, because he had already proven the only point that mattered. You don't need power to confront power. You just need proof, precision, and enough courage to stand still when everyone expects you to fold. And for the first time in his life, the system flinched first. The courtroom was empty now. The microphones had been packed away. The viral clips stopped climbing, replaced by new noise, new stories, new scandals. But something remained, not in headlines, not in hashtags, but in the silence left behind, the kind of silence that settles only after something irreversible has occurred. The boy, he had no interest in fame. He never chased justice like a spotlight. He chased it like air, quietly, relentlessly. And when it came, it didn't roar. It settled, heavy and clean, like the closing of a book that should have never needed to be written. His father was free now, not just legally, but spiritually. He'd returned to his classroom, teaching not just history, but how it feels to live inside it. He let students hold the actual folder his son had used in court. Not because he wanted applause, but because he wanted them to know. This is how truth travels. Folded, battered, annotated by hand. Not perfect, just precise, just real. Outside that school, murals began to appear. First one, then 2. Then a local artist painted the boy, mid-sentence, quoting a line from the hearing. "Your Honor, I speak only to the evidence." Below it, in bold, "Civil rights begin where courage refuses to end." The department changed too. Quiet purges, policies rewritten, mandatory bodycam audits. Sensitivity training became standard, not a checkbox, but a shift. The precinct once known for silence now had oversight from federal monitors. Every report reviewed, every complaint documented. For the first time in decades, the community began walking into the station without fear, to ask questions, not beg for answers. No one said it out loud, but everyone knew. This all started because one kid didn't look down when a judge told him to. And for every child who saw that clip, every black boy labeled aggressive for asking questions, every girl called disrespectful for knowing her rights, there was now proof that knowledge isn't arrogance, it's armor. The DOJ quietly awarded the boy an honorary certificate. It wasn't a press event. It was handed to him in a manila envelope with a handwritten note. "Thank you for reminding us what the law is supposed to do." He didn't frame it. He tucked it inside the same folder. The same folder that had once protected his father. Now it protected a future. Because this wasn't just about one family's justice. It was about a system so used to being unchallenged, it mistook articulation for rebellion. It was about a courtroom so comfortable in its hierarchy, it forgot that the most powerful voice isn't the one behind the bench. It's the one armed with facts, delivered without fear. And maybe, just maybe, that's what real justice looks like. Not a gavel, not applause, but a slow, seismic shift in how truth is carried, how it's spoken, and who is finally allowed to speak it. So the next time someone says, "You're too young to understand the law," or "You don't belong in this courtroom," remember this. There was once a boy with a folder, and because he spoke, everything changed.